Oh my God.
Yeah.
Are you sure? Control is not convenient.
All right, 34 after. I don't want to waste any time here. Elizabeth De La Vega is a former federal prosecutor. She had 20 years experience at that job, and she was also the chief of the San Jose branch of the U.S. Attorney's Office for the Northern District of California. She now writes for The Nation magazine, the Los Angeles Times, Salon, for Tom Dispatch, and she's the author of this book where I read the indictment from, United States versus George W. Bush et al., where she puts out the indictment for not just the president, but the vice president, the former and current secretaries of state, and for the former secretary of defense. It is a conspiracy to defraud the United States, under which she could probably make a very successful prosecution if she were a Congress member. And I welcome her to the show. Hi, Elizabeth. How are you?
Hi, I'm fine. How are you, Randy?
Well, I love reading you. I'm just, I don't know what took me so long to reach out to you and invite you on the show, but today is the day, and I'm glad it finally hit me to use my telephone and call you.
It's this new method of communication.
Isn't it? It's all newfangled and I don't know.
Yeah, it's hard.
I know. I'm an email person.
Yeah.
Well, listen, I just wanted to go through some questions, some very basic questions that I've already put to a libertarian constitutional scholar, Jonathan Turley, and see if there's agreement here.
Okay.
President Bush invokes executive privilege. Is there executive privilege when an underlying crime has occurred? For instance, the released emails that have already been sent to Congress clearly show that Karl Rove and others were using the RNC email servers to communicate White House business to the Department of Justice. That would be a violation, as far as I can tell, of the Presidential Records Act. Is that an underlying crime in the prosecutor's scandal?
Oh, that could definitely be an underlying crime, and there's a lot of evidence that points to that having actually happened. The thing about executive privilege is it's always a balancing test, the need for confidentiality versus the need for disclosure of the information. So the fact that there is evidence of this underlying crime would weigh against the application of the privilege.
Right. As in Nixon, the courts ruled, because executive privilege, again, is not in the Constitution. It's a court-given sort of a principle to the President of the United States.
Right.
And so the court ruled in Nixon that because there was an underlying crime, which was similar to what's going on here with the warrantless wiretapping, it's almost identical except in its scope. Bush took it to an exponential degree. But the underlying crime outweighed the privilege claim.
Right, and actually here there's another factor that weighs against the operation of the privilege, which is that it's supposed to cover presidential deliberations and particularly communications with the president himself. And a number of people have testified that Bush had nothing to do with the firings of the U.S. attorneys. So they've kind of shot themselves in the foot on that argument.
Yeah, I heard that too, and I actually I remember George Bush feigning ignorance that if somebody had done something that they would no longer work for him, and then Gonzalez testified, no, the president wasn't involved in the firing of the prosecutor. So the president has removed himself from just about every decision that's been questioned in the short tenure of the Democratic majority. And therefore, the further away from the president you get, the less the privilege claim can be weighed, right?
Right, and in this case, particularly with respect to Sarah Taylor, she was an aide to Karl Rove. And Karl Rove does not have an executive privilege, much as he would, I assume, wish to have one.
Right, and that's what I brought up previously with Jonathan Turley, who is a constitutional law expert, and I said to him, and he agreed, that Sarah Taylor is being ordered by the president not to talk, although her attorney expresses that she would like to give her testimony. And now I asked, how can, and I'll ask you too, how can an American citizen be ordered to shut up, especially when they're not involved in national security issues and they're not involved in foreign policy, but they are instead involved in the political shop inside of the West Wing?
Well, it does seem as if the president is actually just putting immense pressure on this woman, and I would definitely not want to be in her shoes, but she...
That's what he said.
I'm glad, because he is a constitutional scholar, and I'm just a lowly criminal prosecutor.
Yeah, and a former U.S. attorney. Okay. Yeah.
Assistant U.S. attorney.
Oh, yeah, that makes it just really bad.
Right, but anyway, that is, I think, true.
Yeah, I did too, and of course, I never got my JD, so, you know.
See?
Right?
It's common sense. Actually, that is the case oftentimes, that the law actually reflects common sense, believe it or not.
I do believe it, and I understand what the reasonable man theory is, because I'm a reasonable person of reasonable intellect and a reasonable expectation and a reasonable, curiosity level. So, reasonable prudence, reasonable intellect, that's the standard for fraud. And the president has obviously committed that on any number of issues. But this one, this executive privilege issue, is just yet another fraud. I mean, here you have the president of the United States saying that even his privilege is privileged.
Right. Well, what has always been my theory about criminals is that they catch themselves by going too far.
Yeah.
And I think that's what the president is doing right now.
Okay, so we've discussed the underlying crime and the prosecutorial scandal, and we know there are at least two. There's the Presidential Records Act by using the RNC servers, and there are caging lists. Have you heard about the caging lists that were an attachment to one of the emails that Tim Griffin sent erroneously? He thought he was sending it to the RNC's official website, but he was actually sending it to a parody website. And a journalist named Greg Palast, his friend, owned that GOP parody website and got those emails, presented them to John Conyers, the chairman of the Judiciary Committee. And John Conyers, the reason I believe that they want to talk to Sarah Taylor is because of Monica Goodling's testimony about caging lists being a direct mail term. She's not really sure. But Sarah Taylor knows because she was part of the recipients list of these caging lists. Now that is a lock me up, go to jail felony if you sent mail, direct mail to a, let's say, deployed soldier, which is what they did, marked do not forward, and that soldier was deployed. Therefore, his letter was returned to the RNC, who then, for the first time in the history of the United States, sent challengers into the polling places. And when they got the list of returned mail, they challenged those votes. And over 1 million people were deprived of having their vote counted, and they never knew it because they voted. But it was never counted because they were on these caging lists.
Right, and I do think this whole issue of the Republican National Committee, and particularly led by Karl Rove's attempt to keep people from voting, particularly people whom they thought would vote for Democrats, is kind of an overall theme in so many of the things having to do with the U.S. Attorney scandal. You have the caging. You also have the fact that several of the prosecutors, the U.S. attorneys who were fired, hadn't agreed to go forward with these really bogus cases in their various districts.
Yeah, the fake voter fraud against the Democrats.
Right.
Yeah. It's Karl Rove's. It's the MO of Karl Rove. You actually accuse somebody of doing exactly what you're doing.
Right. It's this projection in this most Machiavellian way, and I think that is one of the underlying goals of Conyers trying to get this information.
Yeah, I know it is. I do. I know it is. The other crime, other than the fraudulent selling and misrepresentation of the facts on this war knowingly, by the way, which is a higher standard than, just even some of the standards that are in the actual, Title 18 section that you cite at the beginning of your indictment in the book U.S. v. Bush. But let's talk about the wiretapping. The president publicly admitted to ordering this crime of warrantless wiretapping. He actually said at first that of course he would get a warrant because the Constitution is in place and, a court order is required. And then later he said, FISA was written in 1978. It's a different world. I don't need no stinking warrant. So the president has admitted by his own, you say criminals catch themselves. He caught himself that day.
He did, and it is actually beyond astounding that Congress has not done anything about this, because none of the reasons that he purports to give now after the fact for why he had to do this hold water by any means whatsoever. I was actually in charge of the U.S. Attorney's Office branch in San Jose during at 9/11, and we had to do all kinds of warrants for emails because we had the ISPs for the area, and we just worked night and day and did all those warrants. People can do the warrants. People in the Department of Justice want to follow the procedures. It's really the president and his group that wants to avoid all these procedures.
Well, wouldn't you want to, as a prosecutor, I would just assume that you would want to follow the procedures so that you could present your evidence in court and not have it, not have the judge rule against you because you got ill-gotten gains.
Oh, absolutely. In fact, I wrote about this a couple of years ago. If they ever did get any evidence, which, by the way, if they're getting all this information, they really have